Question number 301. A agree with B that he will help B in copying in his examination. This is an act of A. criminal conspiracy, abetment, C. common intention, D. common object. Here this correct answer is criminal conspiracy. Question number 302. Which one of the following statement is correct? Options are: in conspiracy there is no distinction between principal and accessory. Option B: in conspiracy principal and accessory are distinct. Option 3: there has to be distinction between principal and accessory in all offences. Option D: none of the above is correct. Here the correct answer is option A, that is, in conspiracy there is no distinction between principal and accessory. Question number 303. A concerts and agrees with B for poisoning C in order to murder him, for which B agrees to procure the poison but did not procure. A and B are guilty of. Options are: abetment of murder by conspiracy, attempt to murder with the aid of section 34, criminal conspiracy to murder C, no offense. Correct answer is option C, that is criminal conspiracy to murder C. Question 304. What is the basic difference between an offense of abetment by conspiracy and the offense of criminal conspiracy? Options are: in the case of conspiracy mere agreement is enough, whereas in case of abetment by conspiracy an act should have taken place in pursuance of conspiracy. Option B: there is no difference at all. Option C: in case of conspiracy an act should also have taken place, but in case of abetment by conspiracy no acts need to have taken place. Option D: in case of abetment by conspiracy there need not be an agreement, whereas in case of criminal conspiracy agreement is essential. Correct answer is option A, that is, in case of conspiracy mere agreement is enough, whereas in case of abetment by conspiracy an act should have taken place in pursuance of the conspiracy. This is the basic difference between offense of abetment by conspiracy and the offense of criminal conspiracy. Now let us proceed to question number 305. Waging or attempting to wage war or abetting waging of war against the government of India is punishable under. Correct answer is section 121. Question number 306. Whoever wages war against the government of India or attempt to wage war shall be punished with. Options are: imprisonment up to 14 years with fine, death or imprisonment of life with fine, imprisonment up to 10 years with fine, imprisonment up to 7 years with fine. In question number 306, correct answer is option B, that is, whoever wages war against the government of India or attempt to wage war, such shall be punished with death or imprisonment of life with fine. Question number 307. Under which of the following sections of IPC a conspiracy to wage war against the government of India is punishable? Correct answer is section 121A. In section 121A, a conspiracy to wage war against the government of India is punishable. Question number 308. Which section of the IPC defines sedition? Options are: section 122, section 123, section 124, section 124A. Correct answer is section 124A. In section 124A, sedition has defined in IPC. Question number 309. The ambit and the scope of offence of sedition under section 124A of the IPC was considered by a 5-judge constitutional bench of the Supreme Court of India in the case of. Here the correct answer is Kedar Nath Singh versus State of Bihar. This is the landmark judgment related to sedition. Question number 310. Under section 124A of IPC prescribes punishment for. Options are: sedition, waging war against the government of India, abetting mutiny, aiding escape of a prisoner. Correct answer is option A, that is sedition. In section 124A of IPC, punishment for sedition is prescribed. Which of the following is neither an offence against person nor against property? Correct answer is sedition. Sedition is not an offence against a person nor against property, but it is an offence against country. Question number 312. Which one of the following is an essential ingredient of sedition? Here we will discuss the essential ingredient of sedition. Options are: dishonest intention, malified intention, words spoken must cause public disorder by acts of violence, words spoken must be capable of exciting disaffection towards the government. In 312, correct answer is option D. The essential ingredient of sedition is words spoken must be capable of exciting disaffection towards the government. Question number 313. Which one of the following is sufficient to prove the offence of sedition? Options are: comments expressing disapproval of the policies of the government with a view to obtain a change in policies by lawful means. Option B, proof of disloyalty or ill feelings. Option C, comments expressing disapproval of the administrative action even though these do not excite hatred or disloyalty. Option D, exciting disaffection towards the government. Correct answer in question number 313 is D, disaffection towards the government. Question number 314. Which of the following is a case decided by a federal court on section 124 of AIPC? Options are Kedarnath Singh versus State, Nehrendu Dutt versus Emperor, Queen Empress versus Bal Gangadhar Tilak, Emperor versus Sadashiv Narayan. Correct answer is Nehrendu Dutt versus Emperor is a case decided by the federal court on section 124A of IPC. Question number 315. Which one of the following is punishable as sedition? Options are bitter criticism of the government to overthrow it. Option B, inducing people to cease to obey law and lawful authority. Option C, a publicist attack on the policies of the government. Option D, an attempt to remove the ministers from power. Correct answer is option B, that is inducing people to cease to obey law and lawful authority. This will amount to sedition. Question number 316. A sent through the post offices a packet containing seditious publication with a covering letter requesting the addressee to circulate it to others. It was intercepted and never reached the addressee A. Options: A, committed the offence of sedition. Option B, did not commit any offence. Option C, is guilty of inciting communal riot. Option D, is guilty of attempt to commit sedition. Correct answer will be option D, that is will be guilty of an attempt to commit sedition. Here the proper sedition has not been committed because the post was intercepted, but the attempt to commit sedition was held. Question number 370. X, the chairman of a political party during an election campaign, alleged the ruling party was responsible for inflation, increase in crime, scams and corruption, and hence exalted his party members to overthrow the present government. Which of the following statements will be correct? Options are: X is guilty as he was provoking his party men to overthrow the government. Option B, X is not guilty, his acts does not amount to preparation for waging war against the government. Option C, X is not liable as he was saying was true. Option D, X is liable as he was making an irresponsible statement. In 317, correct answer will be option B because it exhaustively explains the situation. X is not guilty as his act does not amount to preparation of waging war against the government. Question number 318. In which of the following section of IPC preparation is punishable? Options are Section 121, 125, 398, Section 122, 125, 399, Section 122, 126, 399, Section 121, 126 and 398. Here the correct answer is option C, that is Section 122, 126 and 399. Section 122 is relating to waging war against Government of India and Section 126 is related to committing depredation on territories of power at peace with Government of India, whereas Section 399 is related to making preparation to commit dacoity. In all these sections, preparation is punishable in IPC. Question number 319. Which of the following is not punishable under the IPC? Options are preparation to wage war against the state, preparation to commit murder, preparation to commit dacoity, preparation to commit depredation on the territory of friendly power. Here the correct answer is option B, that is preparation to commit murder. Preparation to commit murder is not punishable. Murder and culpable homicide not amounting to murder is punishable. Whereas preparation to wage war against the state is punishable, preparation to commit dacoity is punishable, and preparation to commit depredation on the territory of a friendly power is also punishable. All these sections we have discussed in the last section, Section 122, Section 126 and Section 399, that is related to preparation to commit dacoity. Question number 320. Match list 1 with list 2 and select the correct answer using the code given below. In list 1, Section 120A. Section 120A is related to criminal conspiracy. Option B, Section 121A. Section 121A is related to conspiracy for waging war. Section 124A. Section 124A is very easy. It is related to sedition. Section 108A. Section 108A is related to abetment of offence outside India. So therefore, correct answer for Section 320 for question 320 will be option B. Question number 321. Which section of IPC provide for the offence relating to Army, Navy and Air Force? Correct answer is option C, that is Section 131 to Section 140. In Section 131 to 140, offences relating to Army, Navy and Air Force are written. Question number 322. Unlawful assembly has been defined in IPC under unlawful assembly has been defined in Section 141. Section 141 exhaustively explains what is unlawful assembly. Question number 323. For an unlawful assembly, the minimum number of persons required is, for an unlawful assembly, the minimum numbers should be 5. Question number 324. Which of the following is not an essential element of unlawful assembly? Options are 5 or more persons. This is an essential element. Common object, common intention to resist the execution of any law or of any legal process. Here it has been asked which of the following is not an essential element. So correct answer will be common intention. Common intention is not an essential element in unlawful assembly, but common object is an essential element in unlawful assembly, including 5 or more person, and to resist the execution of any law or any legal process. Now let us proceed to question number 325. For an unlawful assembly must have a common object of the kind specified in option section 140 IPC, section 141 of IPC, section 142 of IPC, section 144 of IPC. Correct answer is section 141 of IPC. Question number 326. Joining unlawful assembly armed with deadly weapon has been dealt with under dash of the IPC. Options are section 141, section 142, section 143, section 144. Correct answer is section 144. In section 144, joining unlawful assembly armed with deadly weapon has been described in IPC. Question number 327. Rioting means use of force or violence by an unlawful assembly or by a member thereof in prosecution of a common object of such assembly as per section 144 of IPC, section 145 of IPC, section 146 of IPC, section 148 of IPC. Here the correct answer is section 146 of IPC. Question number 328. Use of violence by a member of an assembly of 5 or more persons in furtherance of common object will constitute. Correct answer is rioting. Question number 329. In IPC, punishment for rioting is provided in section 147. Question number 330. Punishment for rioting under IPC is for 2 years only, for 3 years only, for 2 years or fine or both, for 3 years or fine or both. Correct answer is option C, that is for 2 years or fine or both is the punishment for rioting under IPC. Question number 331. Rioting while armed with deadly weapon is punishable under IPC in options are section 159, section 146, section 147, section 148. Correct answer is option D, that is section 148. Rioting while armed with deadly weapon is punishable in section 148 of IPC. Question number 332. Section 149 of IPC is a declaratory provision, creates a distinct offence, a rule of evidence, all of the above. Correct answer is creates a distinct offence. Question number 333. For an application of section 149 of IPC, the offender must be a member of an unlawful assembly. The offence must have committed in prosecution of the common object, both A and B, either A or B. Here the correct answer is option C, that is both A and B. For an application of section 149, the offender must be member of unlawful assembly and the offence must have been committed in prosecution of a common object. Common object, unlawful assembly will be essential ingredient for section 149 of IPC. Question number 334. The ingredient of section 149 of IPC are, options are knowledge or the probability of the commission of the offence, common intention, unlawful object stated in section 141 of IPC, active participation in commission of crime. Select the correct answer using the codes given below. According to the codes, the correct answer is 1 and 3. Option D will be the correct answer, that is knowledge of the probability of the commission of offence and unlawful object stated in section 141 of IPC. 1 and 3. Question number 335. Which one of the following correctly brings out the main distinction between common intention and common object? Options are common intention creates specific offence whereas common object does not. Common intention as well as common object create specific offence. Common object creates specific offence whereas common intention does not. Both common object as well as common intention do not create specific offence. In 335, correct answer is option C, that is common objects create specific offence whereas common intention does not create a specific offence. This is the correct answer. Question number 336. Which one of the following section of IPC uses the word wantonly? Options are section 272, section 172, section 153, section 253. Correct answer is section 153. Question number 337. Promoting enmity between different group on grounds of religion is punished with IPC under section 151, section 153, section 153A, section 153B. Correct answer is section 153A. Promoting enmity between different groups on grounds of religion is punished. Question number 338. Under which one of the following sections of the IPC promoting enmity between different groups on grounds of religion, race, place of birth, residence, language, etc. and doing acts prejudicial to the maintenance of harmony has been dealt with? Correct answer is section 153A. 339. Section 153AA has been inserted in IPC by which of the following Criminal Law Amendment Act? Options are Act of 2001, Act of 2003, Act of 2005, Act of 2006. Correct answer is Act of 2005. Question number 340. Imputations, assertions prejudicial to national integration have been provided under which one of the following sections of IPC? Options are Section 154, Section 153A, Section 153B, D, none of the above. Correct answer is option C, that is section 153B. Imputations, assertions prejudicial to national integration have been provided under section 153B of IPC. Question number 341. Which one of the following section of IPC deals with vicarious liability? Options are section 120A, section 121, section 154, section 159. Correct answer is option C, that is section 154. Section 154 of IPC deals with vicarious liability. Question number 342. Which one of the following section of IPC is an extension of the principle of respondent superior to criminal law? Options are section 121, section 159, section 120A, section 154. Correct answer is section 154. Question number 343. Under IPC, the offence of affray has been defined in, correct answer is section 159. In section 159, the offence of affray has been defined. Question number 344. Which offence does not require the minimum number of 5 persons? Options are rioting, dacoity, affray, none of these. Correct answer is affray. In affray, the minimum number of 5 persons are not required, only 2 persons is required. Question number 345. When 2 or more persons fight in a public place and commit breach of peace, they commit, correct answer is affray. When 2 persons fight in a public place and commit breach of peace, they commit affray. Question number 346. To constitute the crime of affray, what is necessary among the followings? Options are fighting at least 5 persons, fighting in public place, fighting in a market, use of weapons. Correct answer is option B, that is fighting in a public place. Question number 347. Which one of the following offences cannot be committed at a private place? Murder, assault, riot, affray. Correct answer is affray. Affray has to be committed at a public place, whereas riot can be committed at private place. Question number 348. Which of the following does not constitute an offence of affray? Options are 5 or more persons by fighting in public place disturb the public peace. Correct answer is option A, that is 5 or more persons. Only 2 persons required to commit an affray by fighting in a public place or disturbing the public peace. Question number 349. Minimum number of persons required for affray under section 159 of IPC is, correct answer is option B, that is 2. This I have already discussed in last question. Question number 350. Maximum sentence of imprisonment that can be awarded for the offence of affray. Options are 3 months, 2 months, 1 month, 6 months. Correct answer is option C, that is 1 month. Maximum sentence of imprisonment is 1 month that can be awarded for the offence of affray.